Hello and welcome to InsuranceWorldTV, your premier insurance education channel. Today, we are diving into an important topic in the world of insurance. That is, the Subrogation Waiver Clause. This often overlooked aspect of insurance policies can have significant implications. So, let's break it down and make it easy to understand. Chapter 1. What is subrogation? Before we get into the Subrogation Waiver Clause, it's crucial to understand what subrogation is. Subrogation is a legal concept where an insurance company steps into the shoes of the insured to recover costs of a settled claim from a third party that caused a loss. In simpler terms, if your insurer pays for a loss that someone else is responsible for, the insurer can pursue that third party to recover the money paid out. For example, if you're in a car accident caused by another driver and your insurance covers the damage, your insurer may seek to recover the costs from the at-fault driver or their insurance company. Chapter 2: Meaning and application of Subrogation Waiver Clause. Having understood what subrogation is, let's now define what subrogation waiver is. Definition: a subrogation waiver clause, also known as a waiver of subrogation, is a provision in an insurance policy where the insured waives the right of the insurance company to seek recovery from a third party. Essentially, it means that the insurance company cannot pursue the responsible party to recoup the money they paid out for a claim. Application: why would you need a subrogation waiver? There are several scenarios where a subrogation waiver clause might be beneficial. 1. Contractual agreements. In some business arrangements, parties agree to waive subrogation to maintain a good working relationship and avoid legal disputes. For example, in construction contracts, it's common to waive subrogation to prevent lawsuits between contractors and subcontractors. 2. Tenant-landlord relationships. In rental agreements, landlords and tenants might agree to waive subrogation to avoid conflicts and potential lawsuits over damages covered by insurance. 3. Joint ventures. In partnerships or joint ventures, subrogation waivers can help maintain harmony and focus on the project's success rather than legal battles over insurance claims. Chapter 3: How Subrogation Waiver Works. How does a subrogation waiver work? Now that we've covered the basics of what a subrogation waiver is, let's delve into how a subrogation waiver actually works. Understanding the mechanics of this clause will help you see how it fits into the broader context of insurance policies and contracts. 1. Policy inclusion. Explicit clause. A waiver of subrogation must be explicitly included in the insurance policy. It's not something that's automatically assumed, it needs to be clearly stated in the policy document. Standard language. Insurance policies often have standard language for subrogation waivers, but the exact wording can vary depending on the insurer and the specific policy. 2. Endorsement. Policy amendment. In many cases, an endorsement, which is an amendment to the policy, may be added to include the waiver of subrogation. This endorsement modifies the original terms of the insurance contract to incorporate the waiver. Requesting the endorsement. The insured party typically requests this endorsement, and the insurer will provide it, often for an additional premium. 3. Notification. Informing the insurer. The insured must inform the insurer about any contracts or agreements that include a waiver of subrogation clause. This is crucial because the insurer needs to know that they will not be able to pursue recovery from third parties in these specific circumstances. Documentation. Proper documentation and clear communication with the insurer are essential to ensure that all parties are aware of the waiver and its implications. 4. Implementation. Waiving the right. Once the waiver of subrogation is in place, the insurance company agrees to relinquish its right to pursue any third party for recovery of the claim amount paid to the insured. This means that if a third party is responsible for a loss, the insurer cannot go after them to recoup their expenses. Coverage continuation. Despite the waiver, the insurance coverage for the insured remains unaffected. The insurer will still cover the losses as per the policy terms, but they will not engage in subrogation actions. 5. Legal considerations. Contractual agreements. The subrogation waiver must be carefully crafted in contracts to ensure it is legally enforceable. This might involve legal counsel to draft and review the clauses. Jurisdictional variations. The enforceability and implications of subrogation waivers can vary by jurisdiction. It's important to be aware of local laws and regulations that may impact how these waivers are applied. Example scenario. Let's consider a practical example to illustrate how a subrogation waiver works. Imagine you are a contractor working on a construction project. You have a contract with a client that includes a waiver of subrogation clause. During the project, an accident occurs, causing significant damage. Your insurance company covers the cost of the damage under your policy. Without a waiver of subrogation, your insurance company could pursue the client or any other party responsible for the accident to recover the money they paid out. However, because there is a waiver of subrogation clause, Chapter 4: Pros and cons of subrogation waiver clauses. Pros of subrogation waivers. Now, let's take a closer look at the pros of subrogation waivers. Understanding these benefits can help you see why such clauses are often included in various contracts and insurance policies. 1. It maintains relationships. Business relationships. In business, maintaining good relationships is crucial. A subrogation waiver can prevent potential conflicts and lawsuits, which helps keep partnerships and collaborations strong and positive. Personal relationships. In situations like rental agreements, a waiver of subrogation can prevent disputes between landlords and tenants, fostering a more amicable living environment. 2. It simplifies contracts. Ease of negotiation. By including a waiver of subrogation clause, parties can avoid lengthy discussions about liability and recovery. This can streamline the contract negotiation process, saving time and reducing legal expenses. Clearer agreements. Contracts with a waiver of subrogation are often clearer and more straightforward, as they eliminate the need for detailed provisions about subrogation rights and recovery procedures. 3. It reduces legal costs. Avoids litigation. By waiving subrogation rights, parties can avoid potential lawsuits related to recovery claims. This can significantly reduce legal costs and the time spent on legal proceedings. Less dispute resolution. Fewer conflicts mean less need for mediation, arbitration, or court cases, which can be costly and time-consuming. 4. Risk management. Predictable outcomes. Waiving subrogation can lead to more predictable outcomes in the event of a loss. Without the possibility of subrogation, parties know in advance that they won't be pursuing recovery from each other, which can simplify financial planning and risk management. Improved trust. In joint ventures or collaborative projects, a waiver of subrogation can enhance trust among partners, knowing that their mutual interests are protected without the threat of future recovery actions. Cons of subrogation waivers. While subrogation waivers have several advantages, they also come with some drawbacks. Understanding these cons is crucial for making informed decisions about including such clauses in your insurance policies and contracts. 1. Increased premiums. Insurers may charge higher premiums for policies that include a subrogation waiver. Since the insurance company loses the ability to recover costs from third parties, they may pass this risk on to the insured through increased premiums. Additional fees. There might also be additional fees for adding a waiver of subrogation endorsement to an existing policy. 2. Limited recovery. When subrogation is waived, the insurer cannot recover the payout from the third party responsible for the loss. This means the insured may bear more financial responsibility for losses, especially if they cannot pass these costs on to another party. Absorbing losses. In some cases, the insured might have to absorb the losses themselves if their insurance doesn't fully cover the damage or if they have a high deductible. 3. Potential for abuse and increased moral hazard. Knowing that the insurer cannot pursue recovery might lead to negligent behavior. For example, contractors might be less careful in their work if they know their clients can't subrogate against them for damages. Reduced incentive for safety. Similarly, in joint ventures or partnerships, the absence of subrogation rights might reduce the incentive for maintaining high safety and operational standards. 4. Contractual complexity/detailed negotiations. While waiving subrogation can simplify some aspects of contracts, it can also complicate others. Parties need to carefully negotiate and clearly outline the waiver terms to avoid future disputes. Legal ambiguities. If not properly drafted, a subrogation waiver clause can lead to ambiguities and misunderstandings, potentially resulting in legal disputes over its interpretation and application. 5. Impact on risk management resulting in increased risk exposure. By waiving subrogation, insured parties increase their exposure to risk, as they cannot transfer the financial burden of a loss to the responsible party. This can impact their overall risk management strategy. Insurance policy limits. Subrogation waivers might lead to higher overall losses, which could exceed policy limits and leave the insured with significant out-of-pocket expenses. Final thoughts. Understanding the subrogation waiver clause is crucial for anyone dealing with insurance policies, whether in business, rental agreements, or joint ventures. It's a powerful tool to manage relationships and avoid legal conflicts, but it also comes with potential costs. If you found this explanation helpful, don't forget to like, subscribe, and hit the bell icon for more insightful content on insurance and other related topics. If you have any questions or need further clarification, drop a comment below. Thanks for watching.